they are cognizant of the futility of all the individual campaigning environmental groups that get a result which then gets covered over a minute later.
Yeah, as soon as you get
our younger generation understand the problem. Well, they don't. They need this message.
Are you ready? Are you ready? Okay. Good evening, everybody. Thank you for all coming out on a beautiful evening. We hear people talking about human rights and voters' rights and women's rights, children's rights, minority rights, the rights of the elderly, the rights of the disabled. How many people do you hear talking about the rights of the environment, the rights of the planet? And how many people do you hear talking about the rights of communities to determine the kind of environment that they want to live in? Those conversations about rights, those kinds of rights, are just about non-existent today. A community may unanimously vote against having a hog confinement outside its borders. And what happens? The hog confinement comes in anyway. A state may vote to ban RBST milk or to allow toxic waste to come inside its borders. And what happens? A suit is brought and those things happen anyway. So tonight we're going to be hearing from a man who's leading the charge in turning the tide, a leader in securing the rights of communities and even whole countries to make these decisions, and through those rights to secure the rights of our planet. And this is Mr. Tom Linzey, who is pioneering a new paradigm for protecting our planet, and that's a paradigm based on rights. Mr. Linzey is an attorney who's the executive director and chief legal counsel of the Community Environmental Legal Defense Fund. And this organization, this group, is funded entirely by donations. So this has enabled his team for 18 years now to provide free legal representation, and free means no charges or fees, to more than 500 communities and nonprofit organizations across the U.S. to help citizens and towns and cities and counties resist the abuse of corporate power, and also to resist the improper application of state and federal regulations. As you'll hear tonight, Mr. Linzey is not interested in tweaking the system because the system isn't working. It needs to be redesigned from the level of its DNA up, and its DNA are its laws, and even deeper than that, its constitution. And so, Mr. Linzey has worked with the government of Ecuador to rewrite a new constitution, the first constitution ever, and this is a quote, to grant nature the inalienable right to exist, persist, maintain, and regenerate its vital cycles, structure, functions, and its processes in evolution. Great achievement. And similarly, at the level of communities, where he works with communities to change the laws so that people regard their local ecosystem not as property that we can do anything we want with, but as something that has its own rights as right-bearing entities. Just a little bit about Mr. Linzey. He's a cum laude graduate of Widener Law School in Delaware. He's a 3-time recipient of Widener's Public Interest Law Award. He was a finalist for the Ford Foundation's Leadership for a Changing World Award. He's a recipient of the Pennsylvania Farmer Union's Golden Triangle Legislative Award. He's admitted to practice in the U.S. Supreme Court as well as various circuit courts of appeals around the country. He's a co-founder of the Daniel Pennock Democracy School, which is now teaching in 24 states around the country. This school assists in creating community campaigns, teaching citizens and local officials about their legal rights and how to effectively defend against corporate projects that are causing health problems in those communities and the destruction of those environments. He's the author of the book, Be the Change, How to Get What You Want in Your Community, published 4 years ago. And he has served as co-host of Democracy Matters, a public affairs radio show broadcast out of Spokane, Washington. He's a frequent lecturer at universities and conferences across the country, and we are so fortunate that he has come here to Fairfield, Iowa to speak with us. So please welcome Thomas Linzey.
Thank you. So can everybody hear me? Microphone's on? Yep. So, all right. So I was saying to someone earlier, I feel like I'm trailing an IV stand in the hospital or something. So if I fall on my ass, that's why. It's very good to be back in Fairfield. We, about 8 months ago, did a democracy school here in Fairfield. What's a democracy school? I'm going to talk more about it tonight, but suffice it to say it's a 2-day training of municipal officials, community leaders, activists who are tired of the existing paradigm of how we do activist work in the country. Folks who have gotten fed up with running on the endless hamster wheel that tends to be the activism that we've done over the past 40 years, which in some ways hasn't made the place any better. And in fact, by almost every major environmental statistic, at least, has made things worse. So I'm here as part of a trip to Australia and New Zealand, inching my way westward, and should have shut my mouth, but told folks I was making the trip, and then folks started filling in the days before I was to leave for Hawaii and Australia with other events. And so I'm very happy that we were able to work this in. I'm headed to Colorado tomorrow and then to Oregon the day after, where folks in Colorado are dealing with fracking, natural gas fracking, and folks in Oregon are dealing with genetically modified seeds, so GMOs in a couple rural counties in Oregon. So let's get started and dig in. The Community Environmental Legal Defense Fund, what the hell is that, right? It's a mouthful. It's my employer. It's a law firm. And we started the Community Environmental Legal Defense Fund in 1995, so we've been around for a little while. In law school, the third year of law school, which is, the old joke is that they bore you, they work you to death the first year, and then they bore you to death for the third year in law school, which is mostly true. And so the third year in law school, we're working on environmental law projects and in central Pennsylvania. And we start being approached by community groups that are facing things like toxic waste incinerators or landfills or hog factory farms that are being slated for their community, so to be sited in their community. And the reason why they were coming to us as law students was because the cost of legal services today is outrageous. In fact, 15 years ago, it was still outrageous, which was about $500 an hour. Now I have colleagues that are charging $1,200 an hour for specialty environmental services. A lot of community organizations don't have 2 dimes to rub together. You got to pay for photocopies and gas and all that kind of stuff, and don't have the money to hire a lawyer to review a permit or counsel someone on an ordinance or do that kind of stuff. And so walking in through the law school doors, and they would find us through the faculty advisors, we had community groups coming in saying, we need help. We need help with this permit. We need help with this or that. And we had to, at that point, carefully explain to people that to practice law on their behalf would have been a violation of the law because we had not passed the bar yet. But we did what we could to help folks out. We taught them how to use the law library. We taught them how to file comments and petitions and those types of things. We basically took them and globalized the practice of law. We made citizen lawyers of folks in those community groups. And the situation then is much like the situation today, which is there are only 200 full-time public interest environmental lawyers in the United States today. There are only 200 full-time public interest environmental lawyers in the United States today. And so if you're a community organization and you can't afford market value legal services, you turn to one of these public interest groups to try to find a lawyer to help you out. And so upon graduating and passing the bar, we decided that we were going to set up our own law firm, which, looking back on it, is kind of crazy, but we did it anyway. I think I made $2,500 the first year. And we started our law firm to do one thing, which was to provide free legal services to community organizations working on conservation issues. It seemed very straightforward to us at the time, because in law school, the professors and the law school curriculum teach you that in the United States, we have the best environmental laws in the world. In fact, that our environmental laws are so good in the United States that we export them out to other countries. And by God, we've run into those environmental laws now in Nepal and the Maldives and different places where our stuff has now been exported, through various U.S. governmental entities exporting environmental laws, including university faculty, law school faculty, including some of the ones from my law school. And so after learning that we have the best environmental laws in the entire world, and yet looking out our window and seeing things continuously get worse, the question to us is why were things getting worse? And the answer must be, at that point in time, that there's not enough enforcement, right? You only have 200 public interest environmental lawyers. You have the best environmental laws in the world. So the problem must be you just don't have enough lawyers to enforce these really good laws that we have in the United States. And so we set out on a quest to create a couple more lawyers who would help those community organizations. And as you can imagine, when you hang out your shingle and it says free legal services, that the line forms around the block and the phone starts ringing off the hook, which is exactly what happened. At one point in Pennsylvania, we had 300 organizational clients in PA. These were community groups, neighborhood organizations, people that got together around a kitchen table and said, we got a problem here and we need help of some kind. Those were and still are, in many cases, our clients. It's also the only place I think democracy happens in the United States anymore, is really around those kitchen tables in those communities with an imminent problem coming in, neighbors talking to neighbors, crossing political lines. I mean, all that kind of stuff actually happens. It sounds corny, but it does actually happen in places. And so the calls that would come in from these community organizations would always be the same. I lovingly refer back to this period of time, which was about 95 to 2001, 2002, as Groundhog Day. I don't know how many people have seen Groundhog Day, the movie, with Bill Murray. All right, a lot of hands going up. For those who haven't, Bill Murray lives the same day over and over and over again. It happens to be Groundhog Day in my home state of Pennsylvania, in Punxsutawney, where the groundhog comes out and forecasts the weather about whether we're going to have more winter. And in fact, Bill Murray gets so discouraged by living the same day over and over again that eventually he throws a plugged-in toaster into the bathtub with him to try to stop the day from happening again, from reliving it. Our Groundhog Day happened back then a number of times when the community group would call us and they would say, listen, we have a 15,000 head hog factory farm that's been proposed by Smithfield Foods Corporation to come into our community, and we don't want it. Our vision of sustainable agriculture does not include Smithfield Foods putting in a 15,000 head hog factory farm in the middle of our community. Could have been for any reason, and often was for a lot of different reasons, that they didn't want it. Could be water pollution, the potential for water pollution, the economics of the issue about family farmers being driven out of business by these concentrated animal feeding operations and vertical integration by the 4 corporations that control 80% of pork production now in the United States. Could have been all kinds of different issues that people cared about, but they were very clear. We don't want it. We don't want it here. We want to stop it. To which we, as young lawyers out of law school, had to patiently explain to people that they couldn't frontally say no to the factory farm. In other words, that the system of law that we have in the United States is that if a state allows a use, in other words, they issue a permit for something, a project, could be a factory farm, could be an incinerator, whatever, that a municipality is prohibited from banning that use. I'll say it again. The system of law that we have, if something's been deemed a legal use, L-E-G-A-L, under the law, that a municipality is prohibited from banning that use. Black letter, well-settled law. You can ask the environmental lawyers, you ask the corporate lawyers, doesn't matter who you ask, that's the rule of law in the United States today. Some people say, well, wait a minute, that's not true. We have zoning ordinances, we have land use ordinances, we have stuff that we can use to stop things in the community. Well, zoning ordinances are about separating out incompatible land uses, residential from commercial, commercial from industrial. That's their use. If you attempt to use a zoning ordinance to outzone a legal use in the community, what you're looking at is a big fat lawsuit from the corporation that's been affected by that outzone. In other words, using the zoning ordinance not to separate out incompatible land uses, but actually to ban a legal land use within the community. It's happened thousands of times. And what happens is you run into a web of rights that have been created by the judiciary and by other parts of the system to keep municipalities subordinate to state control. It's called preemption. It's got a mixture of that in it as well. To which the folks on the other end of the phone, 1996, 97 into 2000 would say, wow, that's really shitty. And we would say, we agree with you, but that's the law. And the group would say, well, what can you do to help us? And we would say, well, for this particular facility to go in, the corporation needs a permit from the state. The state agency has to issue a permit to the corporation. And as environmental lawyers, that's what we do. We come in and actually challenge the permits that have been issued. Now, that process, which we've been doing for 40 years and is the predominant method of practicing environmental law in the United States. So this isn't just one vehicle, it's actually a predominant vehicle of environmental law in the United States. Involves taking the permit application that's filed by the company, 400, 500 pages, all the nitty-gritty stuff, and then the regulations themselves, which are on the books as state code or state regulatory regimes, and then comparing the two to try to find something that's missing from the corporate permit application. So the whole gig as environmental lawyers is to try to find gaps, omissions, or deficiencies within the permit application to make the argument to the judge that the state never should have issued the permit because the permit wasn't administratively complete. In other words, it missed things that should have been in the regulations. And just to bring this from the abstract down to the absolute concrete, we worked on a number of cases dealing with toxic waste incinerators. Pennsylvania, if you're going to put in an incinerator, you have to post a bond to take care of road damage that might be caused by your trucks. It's all very mundane stuff, but anyway. So your truck's coming in and out of the incinerator, there may be road damage. To take care of that damage, you have to post a bond. Back then, the bond had to be $500,000. So if the roads got screwed up, then there was a bond that could be taken to actually fix the roads. Makes a lot of sense, right? And so some of these permit applications would be filed, but they wouldn't have the bond. The bond would only be $250,000 or $100,000. In addition, there was another section of the regulations that said the president of the company had to sign the permit application. But lo and behold, as we're flipping through page number 350, the president didn't sign it, but the secretary signed it. Or there needed to be a water study attached to the permit application, and there was one, but it was 30 years old. In other words, it didn't come up to snuff about what the regulations required. So we would walk into the courts and say, Your Honor, under section little 2, little c, little I, little Roman numeral 2, little e, little I, under section 25 of the incinerator regulations requires a signature or a bond amount that wasn't met in this permit application. And therefore, Your Honor, it was issued, it shouldn't have been issued, and we want you to overturn it. 90% of the time, the judge would agree with us. It wasn't because we were silver-tongued or had found something that nobody else could have found. It was just the fact that 90% of permits are issued without any opposition whatsoever. So permits are issued as a matter of course. The corporations don't particularly care about the permit applications because most of them don't get challenged. So it's one case in which if you just show up, sometimes that's 3/4 of the battle. And so we would show up and make the arguments to the judge, and the judge would agree with us, and he would throw the permit out. And what would happen next in that particular community? They'd have a victory party. They'd invite us back to the house of one of the community members. They'd have beer, they'd have snacks, have wine, and they'd all pat themselves on the back and they'd say, the system works. We came around our kitchen table, we decided to take action, we found a lawyer, we found the right judge said the right things, the lawyer said the right things, and now we're not going to get the toxic waste incinerator. We're not going to get the factory farm in our community. Well, what would happen next? A month later, or 2 months, whatever, depending on how much of a hurry the company was in, is that the company would come back. And this time they come back with a new and improved permit application. And they would take the gaps and omissions and deficiencies that we found and actually fill them in. Was it missing a bond? Here's the bond. If it's missing a signature, we're going to fill that in as well. And the group would come back to us. Sometimes this was 10 different cycles because the corporate permit writers just aren't that good. I mean, they miss a lot of things, and they would keep going. So 10 different cycles, and the lawyers were billing on the other side. So everybody was happy with the situation. And so to compress it down, the community group would come back to us and they'd say, Mr. Linzey, we need you to do that jujitsu again that you did the first time around because we don't want this thing in our community. And we would end up looking at the community group and saying, we're sorry, there's nothing else we can do for you because all the levers are now gone. All the gaps, omissions, and deficiencies that we had identified, they've now been filled in, and there's nothing else we can do for you in terms of representation. I had lawyers from the Waste Management Corporation, one of the companies we went up against several times, come over to me after permit hearings and thank me for actually finding the omissions, gaps, and deficiencies that they had not discovered because it, in effect, made their job easier because then they could inform their client about what needed to happen to actually complete the permit application. Needless to say, experiences like that leave a sour taste in your mouth. And we went through it many times with many different groups holding their hands as they lost or won in the regulatory process. And in the end, we weren't stopping anything. Toxic waste incinerators are going, factory farms are going, you name it, whatever we were trying to stop just wasn't being stopped. What was fascinating to me at that point in time of our evolution was that it didn't seem to matter that we weren't being successful in the long run to the liberal progressive community that exists in the United States. So even though we had a win-loss record, of 120 or whatever it was a good number. If you actually walked into the communities that we were representing, you'd see no resemblance between the win-loss record that we had achieved and the actual status of the community that we were trying to help. But that didn't seem to matter to some groups and people. We got invited to the White House by Al Gore as one of the best environmental law firms in the nation one year. I still have the invitation. I never went. We got the funding and we got the recognition and we got everything that comes with being a successful environmental lawyer. The concept from their side was that we were fighting the good fight, right? It didn't matter what the long-term consequences of that were. We were just being good environmental lawyers. And so all that stuff came to roost on us, which started to build a cognitive dissonance in our brain about whether this stuff was actually intended to protect communities or whether it was intended to make us look busy while we're billing hours out to other groups. It was at that point in time that a woman named Jane Ann Morris, who we use in our democracy school materials, she lives in Wisconsin. She's a corporate historian, is the type of stuff she does. And she said something to me that resonates with me today, which is she said, the only thing that environmental regulations regulate are environmentalists. The only thing that environmental regulations regulate are environmentalists. Because the regulatory structure that's been put together for us when we walk into those fights, and it's all pre-done. The corporations have written the regulatory schematics, the regulatory schemes, they've written the Oil and Gas Acts, they've written the Nutrient Management Acts, they've written the state law that governs all this stuff. That when we walk in to actually fight something and we agree to fight it on their terms under the regulatory stuff that they've given us to fight under, it's a script that's been written for us to follow, and it makes our opposition predictable. And if we actually think that the corporations have written laws to allow themselves to come in to a community, to actually force themselves into a community, because it's a forcible issue, and left an opening for us to actually say no to them coming in when they were the ones that wrote the very regulations that ostensibly are supposed to be regulating them, it's the very definition of insanity to anyone, I think, that looks at the picture, doing the same thing over and over again, yet expecting a different result the next time you do it. And so in some ways, it's an endless hamster wheel when we get involved in these fights. And this afternoon when I was teaching a class here, we used a triangle. It's like a regulatory triangle. Group emerges to fight a project. The first call they make is to the state. The state says, oh, we're so happy that you're here as a stakeholder. We want you to participate in this permit process. And when they call the environmental groups up to get a lawyer, the environmental groups say, oh, it's great you called. We want you to participate in the permit process. And like cattle down a chute where they get shot with the stun gun at the bottom in that regulatory point, where all you can talk about is setbacks and buffers, and you can't talk about the real issues about suicide among farmers is the #1 cause of death for farmers nationally, starting in 2008, non-natural death. You can't talk about farmers being, a way of life being destroyed. You can't talk about water pollution. You can't talk about these things because it's all been preordained for you within that regulatory construct that the corporations have created. And so in some ways, it's like the Matrix in many ways. We go through the steps. We call the whole thing a democracy, but it's really hard to imagine what aspect of it is actually democratic. When communities can't actually decide what they will look like 20 or 40 or 60 years from now because they can't build sustainability through using the law. The corporate boys are in a much different camp. They use the law routinely to actually engender unsustainability. So they're using the law all the time. We don't. We write letters to Congress, we buy Priuses, we change our light bulbs, we do all that stuff about voluntary activism on our own. But we shy away from actually using the law itself in the same way that the corporations do. Instead, we just tend to accept it and move into those forums that we think that we can win something within. That's been our history of activism. So that's the depressing part. The other depressing part was that Jane Ann Morris reminded me that all the monies that the corporations were spending in defense of our actions, our permit appeals, because we thought at least we were causing the corporations some pain. The corporate entity had to pay lawyers to come in on the other side and fight it out with us. It was then that we learned that the money spent by the corporate lawyers for their own defense in these actions is tax deductible. It's tax deductible as a reasonable and necessary business expense under the code. And so we came to a series of awakenings at some point. Well, lucky for us, the phone calls began to change as well. Something was in the water, something was in the air, I don't know what it was, but people were watching this game be played over and over again. We're starting to come to a different level of awareness about what was happening to them. And so the phone calls, which started the same as the Groundhog Day stuff before, actually started to go someplace. And so community groups would call us and they'd say, hey, we have this factory farm coming in, we want to stop it. And we would have the pre-tape reel in our heads. We'd hit the button and out would come, well, you can't say no to it because the state's issued a permit, it's legal. You can't ban it at the local level because you'll then get sued by the corporation. So we gave the speech to folks. And then we would get to the part about being sued by corporations. So we'd say, well, the corporation that's affected by what you're going to pass, like Smithfield Foods or one of the big ag companies, is going to sue your municipality. And they're going to sue your municipality for violating the corporation's constitutional rights, right? Because in the United States, corporations have constitutional rights. They have the same constitutional rights as you or I. They have First Amendment free speech rights, which they used to overturn campaign finance laws recently in the Citizens United case. They have search and seizure laws, which now ban all unannounced warrantless searches of workplaces like OSHA and those types of things. In other words, corporations have shields built in now with these constitutional protections and have the rights of persons, as strange as that always sounds. They have personhood rights, so they have the same rights as you. And by virtue of their wealth, they have many more rights than you do. So in essence, we have a system in which the corporations that are coming in to do business in your community have more rights than the people living there. That's in essence the structure of law that we have. The community groups, as they were calling in, they would listen to me patiently, and I would say, well, because you'd get sued by corporations, they have constitutional rights. We just took it as a given. Corporations have rights, what you're taught in law school. It is the status of the law. It's well settled ever since 1819, going back that far. And the community groups would say one word. They would say, why? Why do corporations have those rights? We'd say, well, as a learned lawyer, let me explain that to you. And the reason why is because the courts over the last 150 years have actually given corporations rights over the years and done it one right after another. And eventually we've ended up at this place where corporations have these rights and they're going to sue you. They're going to sue the piss out of you if you attempt to actually pass something to frontally say no to this thing coming in. To which the community group on the other end of the phone would go, why? Say, well, it's a long history, but the U.S. Constitution in some ways is structured to place certain values and rights over others. The text of the U.S. Constitution is about commerce and property rights. That's one of the main aspects of protection that's provided by the text of the U.S. Constitution. And it was so easy for the corporations to come in as the main vehicles of property and commerce in the United States and actually take those rights from the Constitution and have them bestowed upon themselves. To which the community group would say, why? We'd say, well, the U.S. Constitution, it borrowed heavily from something called English common law. Talk about snoozeville, right? English common law. Well, English common law started in 1066, and there's the Norman invaders, and they took over England, and then they set up a system of law, which is basically about finders keepers. If we got to break English common law down to barest nuggets, it's about, hey, we found it, now we're going to keep it, and now we're going to subject all you native people, and there were native people in England at the time, to the structure of law that we created. Oh, and by the way, we're then going to use English common law every time we colonize a new place, like whenever we go into Barbados or to India, where the English, sorry, John, I'm going to go. So that the English cut the thumbs off of all the master weavers in India to make them dependent upon English textiles. It was an era of extraordinary violence and subjugation that English common law was imported into those places to actually subjugate the native indigenous peoples to that English system of law. And that's where our Constitution comes from, because the founders, which we'll talk about in a minute, were actually folks that were based in English common law. They thought it was the best system of law ever developed on the globe. And so some of that stuff made it into the U.S. Constitution. And so that's one reason why the constitutional stuff is set up that way. To which the community group would say, well, why was that? And we would at that point say, well, God said so. And because we have no idea why that actually was, but anyway. And so we ran into a series of communities in south central Pennsylvania who weren't willing to take no for an answer. They began to come to grips with the fact that we have a structure of law that gives corporations more rights than the communities in which those corporations seek to do business. And they asked us for help, especially on the factory farm issue. We didn't know shinola about agriculture at the time, but they were looking for a new approach. And so in the very early days of this work, we started talking and discussing things with these community groups about what the real problem was. Is the real problem the flies from the factory farms? Is the real problem the smell or the water pollution? Or is the real problem the fact that a small handful of corporations have now made a decision that factory farming is going to become the predominant method of production for all things agricultural in the United States? And in discussions with these groups, it emerged that, the real issue folks thought was this actual corporatization of agriculture. That corporations, it's not just pork, it's, 4 corporations control 70% of chicken production in the United States. One corporation controls 60% of cheese production in the United States, Kraft. So 60% of all cheese production. So we've had this corporatization of agriculture. Over the past 10 years, we've lost 300,000 farmers in the United States. And we always say lost, such a passive word, like, we're still looking for them. We'll lift up the covers, we don't know where they went. Well, they've been extinguished, and a culture has been extinguished with them. So farm implement dealers, went down the toilet, and open livestock auctions are mostly a thing of the past in most rural areas now because prices are set by contract. And in fact, farmers, when they go to work for one of the big hog production companies, have to sign a contract under which the corporation holds title to their animals. So the animals are actually owned by the corporation unless the animal dies, and then title to the dead animal passes to the farmer under the agreement. It's a standard part of the agreement. So farmers who were once, still integral, but diversified family farmers, it's really a thing of the past now. And there's a serfdom relationship that occurs between the corporations and the farmers. So anyway, in defining the problem as corporatization of agriculture, the solution is not better fly control or better water protection. The solution is to get corporations out of agriculture. And we were lucky, yeah. And we were lucky in that somebody blazed that path before us. Starting in Oklahoma in 1904, 9 Midwestern states began passing laws that banned corporate farming, which said to us something different was happening here. People weren't defining the problem as flies or water pollution or odor pollution or anything else. They were actually defining the problem as corporate control over farming and agriculture. And so we liked those laws so much that we stole them. We took the South Dakota one, which, to make the story even more amazing, folks in South Dakota, not happy with just passing it into statute, actually made it a part of their constitution. The South Dakota Constitution, as Amendment E, as it was known, driven into the Constitution to ban corporate farming. We took that, we made it into a local ordinance. This was the very early days, 2000, 2001, right in there. And the local ordinances that we had that could be passed by a municipality banned corporations from engaging in farming within those municipalities. And I was amazed at how fast it took off. It was like people were waiting to have a conversation like that. People were hungering to have the conversation. But it was almost like the liberal progressive community, and especially the lawyers, my peers, were not interested in engaging in that conversation with communities. And when we opened the box up, the lid of the box, all kinds of stuff started coming out. And people wanted to have that conversation because they understand, pardon my French, that everything's pretty fucked right now. They understand that at a very basic level, that things are really screwed up right now. And that there's a structural problem that exists. It's not just this facility or that facility, that there's a structural issue that exists. There's a power imbalance that exists. So that this we the people stuff, which is, IV dripped into our arms since kindergarten, that we're we the people and this is a democracy and the founding fathers were the best and brightest people ever trod the planet. All that stuff has been put into us from day one. And it's very difficult for us to come to grips with that there's a structural issue in that we may not have democracy at all. The system may be something much different than a democracy. And if that's the case, it calls for more extreme measures than writing a letter to your congressman, urging him to take corporate powers away, which is not going to happen because the whole system is built on that pin. So anyway, to make a long story a little bit longer, the fact is that those ordinances went into South Central Pennsylvania and they started being passed. So these are local governments passing those ordinances. And important to note, these are not liberal, progressive communities. These were rural, conservative, John Deere hat, shit kicker boots kind of places where people were coming to grips with the system of law, having conversations that I couldn't have with my own colleagues and my own peers about what was wrong with stuff. And so it passed in one place, and then it started to travel. Pretty soon we had 14 municipalities that had stood up and said no more corporate farming in our municipalities. And then we had more phone calls coming in because people started to learn about the corporate farming stuff and they wanted to apply it to their own issues. And one of the big issues in Pennsylvania is sewage sludge. We take 60% of sewage sludge that comes right out of our sewage treatment systems and actually apply it to land to grow our food. It actually goes on cropland. It used to be that we dumped it in the ocean off the coast of New Jersey, created a big dead zone off the coast of New Jersey, which is what happens when you dump toxic shit into the ocean. And so we changed that, and the environmental groups came up with this grand plan of actually land application. So what's in the stuff? It can contain up to 80,000 different toxic contaminants. We've had 2 children die in Pennsylvania after being exposed to sludge being dumped next door to them. So it's a big issue. It's not just about, hey, it stinks. It's about, hey, this might kill us, or this might hurt us. And Cornell University tracks a database of all these injuries that have been caused by this toxic soup that's being put on land. So anyway, the community started calling us and said, well, can we use this anti-corporate farming stuff? Can we use it on sludge issues? Because it turns out 4 corporations control 70% of sludge hauling in the United States. They make money by hauling it from the sewage treatment plants. They get paid our dollars, municipal dollars. Then they give it for free to farmers on the back end. That's how they dispose of it after getting paid to take it. And just to let you know how small the world is, one of the biggest sludge companies is Waste Management Corporation, which was recently purchased by the Carlyle Group. So you have the Carlyle Group now owning the corporation that does most of the sludge disposal in the United States. So we began to design ordinances to deal with sludge issues. And first 10 passed the ordinance, then 20, then 60. We were up to 89 different municipalities in the state. And just to give you an idea, that's 10% of all the rural municipalities in the state of Pennsylvania. There was a little rebellion cooking, a little revolt cooking in central Pennsylvania at that point. And because of that, the corporate boys then came in to try to put it down. And they came in with legislation, they came in with lawsuits, all kinds of stuff. But one of the lawsuits that came in was against a small municipality in South Central Pennsylvania who had passed one of our ordinances. And we had tried for years to tell people that it wasn't enough just to ban corporate farming. That the fact is, if you pass that ordinance, you're going to get sued. And the corporation's going to use a variety of doctrines to actually try to overturn what you've passed. And we would tell these elected officials, there's this thing called corporate rights, and corporations have these rights. They can override you. They can sue and overturn your ordinance. To which I got this blank stare from almost everybody. And they would say, well, that may be something you learn in law school, this corporate rights stuff. And it's really academic, and we don't quite understand it, but we're not going to even take time to understand it because we live in a democracy. And we've passed a law. And that law is going to hold because we passed it democratically, And so we couldn't actually make the transition. We needed help. Well, the help came in the form of a lawsuit, which was filed against a little place called Belfast Township in South Central Pennsylvania. The sheriff comes to the door to deliver the lawsuit, to serve the lawsuit to the elected officials. They had passed the anti-corporate farming law. And on the front page of the lawsuit, it says, we are an agribusiness corporation. We are a person under the law. That's what the lawsuit said. And you violated our equal protection 14th Amendment constitutional rights by passing an ordinance that differentiates between corporate farmers and family farmers. So in the U.S. Constitution, you have the 14th Amendment. 14th Amendment mandates equal protection for persons in the United States. Corporations are persons in the United States. So they were arguing that the municipality violated their equal protection rights under the law because it treated family farmers, persons, differently than it treated corporate farmers who were also persons, right? And so I got a call from the supervisors, the elected officials, the same day, and they said, now we understand what you were trying to say. We needed help because nobody was listening to a Tom Linzey or a Ben Price or a Kai Hushka, our organizers, some of our organizers in the United States. They needed a boost, and they needed a boost from the system itself, which walked in the door at just the right time, right? So everybody in the state started hearing about this lawsuit. It became like the thing to talk about in municipal circles. We were on the road, traveling around the state, talking to people about this stuff, kept popping up in different places and people dealing with it. And so we were in one county where all the municipal officials were gathered and wanted us to update them on where things sat. And some guy in the back, some smartass in the back with a John Deere hat stood up and he said, well, Mr. Linzey, what good is passing an ordinance if these corporate rights exist? And the corporations can actually sue the municipality for violating all these other doctrines like preemption and corporationhood and all that kind of stuff. And I said, well, that's what we've been trying to talk to folks about for years. I said, we don't know the solution, but you need to deal with it. There needs to be some kind of mechanism. And he said, well, can you draft us an ordinance that strips corporations of constitutional rights within our municipality? And we said, all right. So we went back to the office and we drafted the ordinance. Turns out the smartass who had asked the question is the chairman of the township supervisors, a little place called Licking Township, Mick Robertson. He was actually eventually on the cover of Mother Jones as a result of what the supervisors did. And they took our ordinance. We didn't know if the level of disobedience had reached that point yet, but it had. They had a public hearing. People walked in, farmers came to the meeting with copies of Common Sense that they had downloaded from the, read from the Pennsylvania Constitution, which says, of course, that the source of all governing authority is the people. It's in all of our constitutions. It's just not real until we make it real. And Licking Township became the first municipality in the United States to actually pass an ordinance that refused to recognize corporate rights within their jurisdiction. And then that started to travel. So that concept started to travel out to other municipalities. Other municipalities said, well, wait a minute, it's not just corporate personhood that's a problem, it's also preemption. If corporations can use the state to preempt us at will, then we need to fix that too. And that seemed to lend itself to an argument about the right to local self-government, which we don't have right now. It's a myth that we have it. The constitutional system recognizes the federal government and state governments. Doesn't say a word about communities, doesn't say a word about municipalities. Municipalities have no rights under the law. If the state of Iowa tomorrow, the legislature took a vote tomorrow to get rid of the Fairfield Municipal Corporation, to actually eliminate Fairfield as a legal municipal corporation city, there's nothing stopping them from doing that. Zero. They can combine, they can get rid of, they can abolish, they can do whatever they choose to the municipality. It's a combination of preemption and something called Dillon's Rule, which essentially says that your municipal government only has the powers given to it by the state. It's a relationship that's deemed to be a parent-child relationship. You have no rights within your municipality as an existing unit because the state can screw with it as much as they want. And in fact, every time they pass a preemption law, they're screwing with the rights and powers that the municipality has because they're actually putting them out of bounds, that you can no longer exercise that particular power. To make a long story a little bit longer, the fact is that in Pennsylvania, we eventually had over 110 municipalities who had passed these laws. It then started to morph into different issues. First, it moved to New England, where in New Hampshire and Maine, folks are dealing with Nestle Corporation, who want to come in and actually stick a straw into their aquifers, bottle water, and then sell it overseas. That's one of the plans that was generated in New Hampshire. Folks in New Hampshire passed an anti-corporate water withdrawal ordinance that also stripped or refused to recognize corporate constitutional rights at the local level, and also began to do something called the rights of nature, which I'll talk about in a second. The work then traveled from New England to Ohio, New York, Colorado, New Mexico, Iowa, where we've done a school, Washington, Oregon, now we're working in Hawaii as well. That it seems to be that people are ready for a revolt. It's an organized revolt, but it is nothing less than a revolt. It's a refusal to obey existing law that guarantees that we're going to get fracked, or that we're going to get drilled, or we're going to get factory farmed, or whatever. And honestly, it takes a different breed of person to actually embrace the organizing. It's not the liberal progressive community. I have a lot of friends in the liberal progressive community, but they distrust democracy itself. They want to get the right people with the right values in office, which is wonderful. But turning control over to the masses to actually make decisions about energy and agriculture and transportation, those types of things, that's the last thing that they want. And so the folks that we work with as clients are only those communities doing this work. We've stopped speaking at conferences, with a rare exception. We've stopped actually going out and doing the stuff that you usually do because we found that it's worthless. The only folks that actually we're interested in talking to now are the folks that are actually going to do it, who are faced with some kind of imminent harm in their community and actually want to put it on the ground. So some of the questions we get before we touch briefly on the rights of nature stuff, and then I'd close up for questions, is some of the questions we get. Well, how can a locality do that? We all know municipalities can't do that, and aren't they just going to get sued? And the answer is yes, they are going to get sued. Very few have up until this point, but there's going to be thousands of lawsuits. There's going to be tens of thousands of lawsuits. There's going to be more than we can even count in lawsuits. And the lawsuits are a good thing. I want to say that again. The lawsuits are a good thing. And the reason why they're a good thing is because right now we have the whole system camouflaged very carefully. Nobody really understands, very few people understand how the system actually functions in practice, about who has rights, who doesn't, who can override who's subordinate to who, why we the people is kind of just a joke. When we talk about making these important decisions about big areas of industry or stuff that affects us very personally in our own communities. The lawsuits are a good thing because they begin to uncover the camouflage that's been carefully put into place. You can't have a people's movement until people actually understand how the system functions. This is about using the energy of the system to pull the corporations into a fight that's rights against rights. It's about no longer participating in the regulatory system, which is about parts per million and who can bring the best expert in to talk about liquid manure application rates and all that kind of stuff. It's actually about fomenting the right confrontations, the confrontations that actually unravel and begin to show to more and more people how the system actually functions. Because unless you have enough people to understand how the system actually functions, you can't build any kind of movement out of it. You can't build a movement out of people who don't understand a structural solution is required. Today, we have enough communities in 8 states who are now stitching themselves together to begin to drive towards state constitutional change. It's a very exciting development over the past year that's been occurring. But get this, communities that are working on different issues that on its surface appear different. You know, water, factory farms, incinerators, you know, the TPP project, the Trans-Pacific Partnership stuff, all these things that would normally be treated as different issues are being treated as the same now in some places because it doesn't matter what your issue is. It doesn't matter what we want, no matter what the issue is. It doesn't matter what we want in our communities because we can't get it. We don't have the legal authority to get it. And so people are joining hands across issue because the issue is not important. It's not the PIN. The PIN is the structure itself that divests us of decision-making authority to decide what happens in our own community. And so the movement that has to take place across community lines. And it's very exciting to me to finally see that happening, but also to see folks sitting down and saying, what do we want our state constitution to look like? You know, what do we want in it, and how do we blueprint that change at the ordinance level, at the local municipal level to drive this train forward? Eventually, and next year we have something on the blotter now, is bringing different states together. These community rights networks that have formed at the state level, bringing them together to begin to envision what a new federal constitution looks like. It might be amendments, it might be changes, but one thing is very clear. We have a 1780s form of governance in the United States, in the U.S. Constitution. When people extol the Constitution, they're not really talking about the text. What they're extolling is the Bill of Rights. And we forget sometimes that the Bill of Rights had to be driven in over the opposition of the founders who drafted the text of the Constitution. States had to refuse to ratify stuff without a Bill of Rights being included in the Constitution. The Constitution has a lot of bad stuff in it. It's used right now as a vehicle by Monsanto, by Waste Management Corporation, by different companies to pummel our states and our localities. You know, it's like when the state of Vermont decided to pass a BGH labeling law. It's not really radical, but back in the 90s, the good people of the state of Vermont said, hey, we want to know what we're eating when we eat dairy products in this state. You know, it's not, once again, not very radical, but the state legislature listened and required dairy producers in the state, dairy sellers, to actually put a label on that says free of bovine growth hormone, actually identify those products that contain bovine growth hormone. The Grocery Retailers Association, of which Monsanto is a member, sued the state of Vermont, contending that the labeling law violated their First Amendment right not to speak. Okay? First Amendment right not to speak. And it will all be really funny, except the fact that they won. and they win every day. It's not the exception that they win, it's the rule, right? This is the way it operates. And in the democracy school, we teach 300 different examples of how corporations use constitutional rights against us. They use our Constitution as a vehicle against us, right? In the 1780s, the founders had no idea about deforestation or climate change or any of the stuff that or acidification of oceans. It didn't even cross their minds. What they saw was a boundless bounty of natural resources across the land, and they needed to write a plan of governance that actually allowed the exploitation of those natural resources to accelerate to become a world power, so that we weren't afraid of England invading us anymore. And we were on a stage, a world stage with those world powers. And by God, they did a really good job, because that's what the constitutional vehicle has protected as the DNA of this country for so long. It's time for a sustainability constitution, right? And that's not going to happen by being nice, right? Work is about confrontation, it's about controversy, it's about actually drawing the conflict, which a lot of people are uncomfortable with. I'm not anymore, because it's the kind of struggle that has to happen in this country to actually build that new constitution. Right now, we have the antithesis of a sustainability constitution. It's used to propel unsustainable activities. It's time for a new plan. Derek Jensen, one of my favorite authors from the Pacific Northwest, he writes in his articles, one of the things he wrote is, he said, do we believe that Monsanto is going to stop Monsantoing if we ask them nicely, right? But that's what we do. We send letters to Congress. We urge people to do stuff. We've become experts at pressure politics, which we think changes something. But in reality, we've ceded the structure of law. The war is over and we lost. We are now after the war. And the question is, Joanna Macy, who some of you may be familiar with, I don't know, she talks about, are we going to be the hospice worker? That actually is the person seeing the death happen and eases it, which is very important. Or are we going to be the person that delivers the new birth? Are we going to be the folks that deliver this new system that needs to come into being? We have to make that decision, because there's too many people and too much resources going into being the hospice worker. And that's important, but we got other work to do. And the only place we can look for that other work, lessons about what needs to happen, is to the prior people's movements that we had in the United States. That's the abolitionists and the suffragists. Little known fact, William Lloyd Garrison, one of the most famous abolitionists, when he gave speeches, he would burn a copy of the Constitution, because he saw the Constitution, which codifies slavery in the text of the Constitution, as an agreement that had to be breached or changed in order for abolition to occur within the United States. And that's why the abolitionists set their frame as actually changing the Constitution. It's also really bad that in this country, corporations became persons 40 years before women became persons for the purpose of suffrage. So in the United States in the 1880s, the Supreme Court said, hey, corporations, you're a person now. But it took women 140 years of organized work to actually achieve the limited right of suffrage. I'm not talking about equal rights, but just suffrage in this country. So it's rigged. The DNA is bad. And we have to get out of the habit of thinking that we can tweak things or fix things. People come to me all the time and say, well, the regulatory system is broken because it's not working to protect us. And I say back to them, it's not broken, it's working perfectly. Because its purpose is not to protect you. Its purpose is actually to enable certain hands to get into your community. And that's what it does perfectly well. So one other thing to talk about tonight, the reason why I'm here actually, is the rights of nature stuff. As the first community in the United States to pass a rights of nature ordinance, tough to get our brains around this sometimes, was a little place called Tamaqua Borough in Schuylkill County, Pennsylvania. Very rural area, but there was a plan by the governor to bring in PCB-laden dredge to dump it in the mine holes. So they have a lot of abandoned mine holes, because one thing we do very well in Pennsylvania is we go into these poor communities and we take all the good stuff out, and then we take all the bad stuff and stick it in. And so that was the plan for this community. They said, we're not going to do that. And we have a lot of concerns, but we want to ban that from happening. So we came in, helped them draft an ordinance. The funniest thing happened was there's a lot of fishermen in the community. There's a lot of sports people. And they said, well, if this thing comes in and actually pollutes a stream or a river that nobody uses for drinking water, but it's there and we fish from it, we enjoy it as an asset in our community, who can protect the river? Right? Who can protect the river if something happens to it? And it started us thinking about how disjointed our environmental laws are, because the environmental laws are all written from a perspective that a human is being injured and then a human is walking in to get redress for his or her injury from the pollution that's occurred. We use the loose term environmental rights, but it really has nothing to do with environmental rights. It has to do with rights of people to exploit the resource. And when they're obstructed from actually exploiting it, then there's a remedy within the courts. And so the fisherman said, well, look, let's say I catch 2 fish in that river a week, and I enjoy it for doing that. If the river is polluted and I go into court trying to get a remedy for that, what's going to happen? Well, what's going to happen is the judge calls the fish market, gets the dollar value of 2 fish a week, and then calculates out 15 years into the future how long the person has viable fishing future, and then awards the fisherman the value of the lost fish that he can no longer fish from the river. The river itself never appears in court. The river itself is never seen by the law. Just like slaves weren't seen in 1840, right? The slaveholder was seen, but the slave wasn't. Couldn't commit murder on a slave. It wasn't a crime. It was a property damage crime because the damage was caused to the slaveholder, right? That was the only interest because the slave was not a person. Women, rape was not illegal as a criminal offense until late 1800s. Prior to that, it was a property damage crime. You paid the husband. And not to be crass, but loss of use was the phrase that was used because the women were not persons. They were actually damages paid to the husband. Okay, so just to let you know how history has run. If you're not a person, you're not seen by the law. You have no rights. You're not a rights holder. Well, there seemed to be something fundamentally wrong with that to us in the way that environmental law operates, because you have a person plaintiff who's going in, or an organizational plaintiff, which is alleging damage to them and their interests, and then seeking a remedy. Even under the federal environmental laws, the citizen supervisions that we used to bring, the citizen suit actions, if there's no settlement and it actually goes to a decision by the court, those monies end up in the general fund treasury. They're paid to the government. They don't even go back to compensate the ecosystem. There's no restoration that takes place. And again, all this is camouflage because nobody really understands. Very few people understand how the actual environmental stuff works. And so in Tamaqua, these fishermen, these sports people came up with the idea of, well, why doesn't the river have rights? Why shouldn't the river have rights? And then we as community members could stand in the shoes of the river to actually bring a suit. And let's provide that the monies that get paid actually for recovery of those damages actually goes to the restoration of the river and is measured by what it takes to restore the river to its prior place. And today that makes a lot of sense to us. Back then we were like, what? Right? Because it's foreign to us. But it's not foreign to us, right? Indigenous peoples for 10,000 years or longer have treated nature as something else other than property, right? Because nature is property under the law. If you have a deed to your parcel of land, to your house, 10-acre parcel of land, it carries with it the right to destroy the ecosystems on that piece of land. It's part of your rights, your bundle of rights as a property owner to destroy the ecosystems. You can make it into an airstrip and concrete the whole thing, and extinguish the ecosystems on that piece of property. That's your right to do under the law, which means that whoever in our culture can own the most nature has the power to destroy the most nature, right? That's the corollary. I mean, that's the logical conclusion. And pretty much that's the way it's worked out. And so indigenous peoples, even in Western white culture, we're usually the last ones to get it. There's a professor called Christopher Stone who wrote a law review article entitled, "What if Trees Had Standing to Be in Court?" Raised the issue about what that would look like. Well, we took it one step further and drafted an ordinance, a rights of nature ordinance for the borough of Tamaqua. And they adopted it. They became the first one in the U.S. to do so. The rights of nature stuff then traveled to other municipalities, most recently the city of Pittsburgh. The city of Pittsburgh City Council unanimously adopted a rights of nature ordinance. Who knew? And then building on all that stuff, we get a call from Ecuador. So the Constitutional Commission that was put together, elected to draft a new constitution for the country of Ecuador. They had heard about Tamaqua. It's a small world, right? They wanted us to come in and tell them the stories about how that stuff happened and to help them actually put it into the Ecuadorian constitution to make Ecuador the first country to move from a regulatory property-based ecosystem rights protection system, which really isn't protection at all, over to a rights-based protection system, We helped them write it. It was approved by the Constitutional Commission after a lot of work, and then was ratified by the people of Ecuador by a 70% vote, making Ecuador the first place. So a lot of people say, well, then what happened? Was it just on paper? Well, no, it's not on paper. The first case was brought about a year after the thing passed. And in these cases, it's important to realize that the plaintiff is not a person under the law. The plaintiff is the river. And so the first case that was brought was the Vilcabamba River versus the province of Loja in Ecuador, right? You see it and you're like, wow, that's really interesting, right? And so what was happening was the local government was dumping gravel from a road construction project into the Vilcabamba River. And it was altering the course of the river. And under Ecuadorian law, you don't have the right to do that. And so they sued in the name of the river. And the judge awarded the river damages, right? And there's been other cases. The Ecuadorian government itself has now used it to stop illegal gold mining in places. And so it's actually being used. We're talking about a test case in Pittsburgh because now the Monongahela River is polluted by fracking chemicals, by upstream frackers, and actually using the rights of nature stuff to go after the upstream frackers. All to say, all of this stuff, whether it's community rights, municipal, rights to the local self-government, rights of nature, they don't exist under the current system of law until we bring them into being. And that's what's starting to happen in the United States now. It's still the beginning of the beginning, but it has to happen. It has to happen around all issues, smart meter issues, which are cropping up in various places. It has to happen around power lines. There's a power project to wheel power down from Quebec to the East Coast that New Hampshire communities are now all riled up about. It has to happen around fracking. It has to happen around GMOs. It has to happen about pesticide application. It has to go after all this stuff because we are so far away from being sustainable that the kind of paradigm shift that has to happen to actually make us sustainable is nothing less than astounding. And it's going to take brave elected officials. It's going to take brave community groups. It's going to take all of us moving together. It's going to take us weathering the corporate assaults that come daily in the media and in the courts and in the legislatures. But in the end, we have to ask ourselves, what are we here for? And what are we waiting for, right? There was a study that came out 3 months ago that from one of the major environmental organizations that said 70% of all biodiversity on the planet has now been extinguished. 70% of all biodiversity on the planet has now been distinguished. What exactly are we waiting for, right? It's my impatience, but what are we waiting for? Where are the 10,000 communities that stand up and say, we're going to seize our municipal corporation and actually drive it upwards against the state and federal vehicles that are now used by corporations to drive X, Y, and Z into our community, right? When is that going to happen? And just to leave with this thought, which is that some people have, compared this as, have talked about this as a model of collective civil disobedience. That in essence, in the 60s, folks sat down at the lunch counter. That was illegal, right? To sit down at the lunch counter. Those kids brought toothbrushes with them because they knew that they were going to be in jail for a while. And they did it anyway, right? And communities today, our places where we live, our neighborhoods, our communities, our municipalities, our cities, our towns, our villages, our townships, they are being used in our name to do horrendous things right now because every day we do not challenge the structure of law is another day that we validate it, right? Because silence is assent under this system. And until we collectively sit in at those lunch counters, until we collectively understand that we need to use stuff that's never been built before, but we need to build it, because otherwise this place is sliding off the cliff, then the longer that takes, the more stuff we lose. And so the question to you is, what are we waiting for? Are we, waiting for someone else to save us? That's been our, track record. But now it's time to take it into our own hands and do it ourselves, which is what all the prior people's movements in the United States have done. And I would submit to you that it's time to do it now. And it's time to do it in Iowa. And it may be time to do it in Fairfield. Because, yeah. So it starts at home. It starts where you live. People are always saying, well, what can I do to support the community rights movement? Well, we say, do it where you live, because that's where it has to be done. Here in Fairfield, we did a democracy school. We have graduates that have come out of the democracy school who now want to set something up to actually begin drafting perhaps what a sustainability bill of rights would look like for the city of Fairfield. Never been done before in that kind of context. And then to work with other communities like Decorah, where we have a democracy school being taught in a couple of weeks, to actually join hands with those folks to begin a statewide process for making change. And that's what needs to happen. So we're here to catalyze and help and support, be the lawyers for, do whatever we can do to help that process along. Bob, do you want to say a couple words? I'll use this. Let's use the mic.
Hello? Hello? Okay, thanks. I have what I think will be. Hello? Hold it close to your mouth. Hello? I think I'll have. How would you like to have a project where our attorney working for free for us would be Thomas Linzey? We have a volunteer sign-up sheet for such a project. It's a move to do exactly what Thomas just said. We want to create a committee of local citizens and visitors to help define what sustainability should mean here in our own community, a community that should lead the world in defining what sustainability really is. So we'll have a sign-up sheet outside. We have the Decorah project that Thomas mentioned. Outside upstairs, there's a table and there'll be a sign-up sheet. There's 4 things I want to tell you. The first thing is the community project that you can volunteer for. The second thing is that although Thomas Community Environmental Legal Defense Fund is a pro bono nonprofit organization, there will be expenses to do this with just practical day-to-day things. So Thomas advised us that we should have a fundraising goal of $3,000. And I can tell you a very interesting thing. We needed to raise part of those funds to cover the expenses for Thomas' visit. And so far we've had about 30 people donate. And it was very interesting to me to see that about 80% of those people are ladies. So the men out here have got a lot of catching up to do, and we're going to give you an opportunity because outside in the hallway there's a donation form that you can use to either write a check or a credit card. And I have a feeling that we could raise the full $3,000 tonight. The third thing I want to tell you about is that there's a lot of education that's required to move from the heroin drip that Tom was talking about, that all the propaganda that we've had growing up. It takes a while to appreciate what is necessary to understand. So one of the best ways to do that is to go through the workshop that Thomas's group offers. There's one coming up in Decorah in September, and there's another similar one in November. And we have the contact information and website information on a sheet that you can take with you also upstairs. And the fourth thing that I wanted to mention, the last thing I wanted to mention, is that you may know that we have a very unique city government opportunity coming up. The city government elections are November 5th, but tomorrow at 5 p.m. is the filing deadline. And we have a very unusual situation in that there are 2 at-large seats in which, because of the retirement of Connie Boyer, and because the other at-large seat is held by someone that Mayor Malloy appointed, in both of those seats, there is no one who has been elected. So it's a very Sotvic situation where we're not running against anybody if we decide to seek those seats. And I want you to know that we're looking for people who are sustainability, the rights of nature, sustainability friendly to run for those seats. So if you're at all interested, please come and talk to us. Simon Davis knows the procedure very well, and he can guide you through that. But Simon Davis. Yeah. So now we're going to turn this back to Thomas because he wants to take questions from the group.
We have mics here and here. We'd like to get your questions on mic, please.
Two short questions. Number one, I don't know if Clyde is here, but Agenda 21 is being done in the name of sustainability, and it puts nature up against human beings. In other words, nature is more important than human beings. Get rid of the human beings. That's one comment, actually, and I want to get your feedback on that. And then another comment is, I think you must be aware that the president, and I'm not talking about the particular president in office now, I'm talking about presidents all the way back, is not the president of this nation. It is he or she, but we haven't had a she yet, is the president considered to be owned by the U.S. Corporation of Washington, D.C., or the
territories. Yeah, second Eileen. The one is Vatican Incorporated, and one is the central city of London called the Crown. And I think that needs to be addressed, that this is not, they own all the corporations. Thank you. Sure. Thank you.
I think that so let me just round out her one question is, could you explain to this group what Agenda 21 or ICLEI is?
Well, that's a long conversation, but all to say it's a United Nations vehicle for environmental sustainability that's drawn the ire of the Tea Party and some other folks. And there's a lot of bad things about Agenda 21, and some of that is about mandating certain changes that take place, and a lot of it's about corporate greening and greenwashing and that kind of stuff.
What happens if there's 20,000 acres somewhere, 20,000 acres, and then a lawyer wants to represent those 20,000 acres as representing the rights of nature?
Yep.
And I don't know who owns it, whether it's a corporation or people own it. And the lawyer takes the case that this 20,000 acres has a right to just exist without any kind of building on it because it's necessary for oxygen production, or maybe it's necessary because of carbon tax or whatever.
That would be crazy.
Well, maybe carbon tax, maybe whatever they're doing with Agenda 21. How does this interface with Agenda 21?
Well, we usually don't talk that much about Agenda 21 questions because it's been thrown around a lot. It sometimes gets in the way of some of these ordinances, and so the ordinances are intended to roll over them. I mean, I guess that's the best answer to you.
How we doing?
Yeah,
there,
I can hear
that's
you now.
better.
Yeah.
I was formerly a registered voter in the state of California. And in the state of California, they have the right of initiative.
Yes.
And for those of you who don't know what that is, voters
I
can,
can repeat it, just say it.
the voters can go around the state legislature
Yes,
acting in the people, but it's paid for by corporate interests,
yes,
to create their own laws and have it put on the back.
yes. No, go ahead. I'll repeat the question.
My question is, how important is the initiative process
Yeah.
in this whole fight?
Yes.
Seemed to me to be quite a weapon.
Yeah.
And number two, I was quite surprised to find that we don't have that in the state of Iowa. When I moved here, I was actually shocked that the people didn't have this right. And I'd like you to comment on that, is the usefulness of the initiative process.
It's essential. The model that's been built, if you can call it a model or blueprint or whatever, is that it means making law. And so his question was aimed at Iowa doesn't have the initiative power. How important is that? We think it's very important. However, you do, in Fairfield at least, have something called the home rule option, where a certain number of people can petition the local government to go home rule and then write a new constitution for the city. So there is an initiative option. It's just not called initiative. It's actually a home rule option. So that comes important when you have municipal bodies that are unwilling to adopt something, and you need to override them. So it's a very valuable tool in that respect as well.
Thomas, I've been following you since I heard you speak at Bioneers a number of times, and I knew then that you had something special going, and thank you so much for your fabulous and courageous work and for coming here and sharing it with us. I have a question. I'm not exactly sure how to formulate it, but we hear so much talk about rights and that corporations have rights. But is there any legal or certainly moral basis for talking about responsibilities as well? And it seems like that angle could be used, and it's certainly missing from the national conversation. Yep. People talk about the Bill of Rights. Is there a Bill of Responsibilities, for instance?
I think the reason why we shy away from talking about responsibilities, at least in the corporate frame, is that you're kind of validating the rights at that point. Mm-hmm. If you're talking about responsibilities, it's almost like the second step. If you have rights, then you have responsibilities. And I think the frame is corporations are property. So you own a corporation, and the corporation itself has rights. Mm-hmm. And so we have a system of law in which property has rights. It's like your refrigerator having rights. Yeah. You know, like your refrigerator being able to sue someone for violating the refrigerator's rights. And so instead of talking about responsibilities, which we heartily, embrace when it comes to the new ordinances we're writing about Bill of Rights expansion at the local level, in the frame of corporations, it doesn't really mesh because it validates the first part. So.
Yeah, okay, so that makes that clear. Thanks so much.
Yeah, thank you. Don't follow me anymore. No, that's right.
I'm interested. I think that this is a brilliant change in perspective, but I'm interested in how this change in perspective will interact with the NIMBY behavior, not in my backyard behavior. So, for example, off the coast of Cape Cod, there was a project to create a large wind farm, which was Cape Wind, which was objected to by the Cape Cod residents, and perhaps being a front for oil and gas industry. I don't know, but anyway, it was put up as a local objection to the wind farm. And maybe a wind farm would be a good idea. So I'm just wondering how it would interact with that.
Yeah, I think there's always some of that. The wind project that you referenced was a challenge because you have very rich people who live in that section of Massachusetts who wanted to stop their view from being damaged by the wind facilities. But this work is not a shortcut for duking it out in the communities over what gets stopped and what doesn't. In other words, there's still a values fight that takes place. The understanding is, let's eliminate the structural impediments and then have the values fight. Let's not have the values fight when we don't have the authority to do something in the first place. And so that's the progression. But yes.
I wanted to suggest that there may be an Achilles heel that could be dealt with in this, and that is to have a corporation file to register to vote.
Yeah.
And take that all the way up.
Yeah. I mean, those types of things have been done. They're stunts. They're like stunts that assume that the existing system and all we can do is draw attention to it kind of thing. There was a guy, I mean, just for shits and giggles, there was a guy in California who incorporated a corporation, left the incorporation papers on his front seat, and then used a high occupancy vehicle lane. And the police pulled him over, and he claimed that there were actually two persons in the vehicle because of the incorporation papers, you know. And so, you know, it gets a laugh and it's fun, but they're basically just stunts. They're things we do because we don't have any real power to do anything else, kind of thing.
An approach in which it was taken by an organization like yours all the way up would have any chance of being other than a stunt?
Well, not that approach. I mean, eventually these cases are going to wind up in front of the U.S. Supreme Court, and then we're going to have to ignore the court's rulings because the courts are set up to interpret existing law. That's what they do. And so the change here has to come textually. It's going to have to be a change of that DNA law and then force the courts to actually subordinate themselves to that new law. So, you know, other people will do stunts. I chuckle. I got a kick out of the HOV lane thing, which I found to be funny. But it doesn't really, in the long term, it doesn't stick with people. It's not structural change. It's actually just a laugh moment. So, you know.
It wouldn't be in a public awareness change in which the...
It doesn't change anything. It's like Facebook, Twitter activism. I mean, it's good for getting people together, but it's not real movement building stuff. It's all kind of superficial.
I have a couple of questions. One is about the corporate farming.
Yeah.
Is it actually fulfilling agricultural zoning, or is it commercial zoning?
Oh.
Because that angle can outlaw corporate farming on basis of zoning.
Yeah, what's interesting is that in those municipalities that we work in, some use the zoning ordinance to actually put concentrated animal feeding operations in a different zone, to say it had to be commercial zone. What happened was the legislature then took the power away from the municipalities to make a differentiation in zoning at the local level for those types of facilities. It became a allowable use in any district, which is what you see the state legislatures doing now. They will override zoning ordinances by making certain uses allowable uses in any district. So by using preemptive power, they've been doing that in the different states.
I see.
So.
And the second question was, is there any way to, let's say Jefferson County would ban GMO seeds on environmental reasons to protect the environment on the behalf of the environment of the Jefferson County? And so we could ban GMO seeds within Jefferson County, period. Could there be a legal ground to do that based on the environment, protecting the right of the environment?
Well, right now there's no legal ground whatsoever to do that. This is about inventing a new legal ground. So, you know, when I said at the beginning, hold on to your wallet, we're going over the wall, it's kind of that way. This is making an escape from that system. And so, you know, it's about building a new law to do that, to recognize an inherent authority to do that.
Thank you.
Thank you, Thomas. Has there been any consideration within the scope of what your legal outfit wants to do, any consideration for that if some of the technologies, just for instance within the area of energy generation, that has been suppressed, you know, because it's more profitable for the large corporations to continue to use coal and oil and natural gas and nuclear, creating a legal situation where they would be forced not to continue to sequester some of these things like cold fusion and Tesla technologies and such.
I haven't given much thought to it, but it's certainly something somebody could do.
Well, the reason that I brought it up is because some of the issues about sustainability would be much less prescient, much less damaging to the environment if we didn't have to burn coal and didn't have to burn oil.
We're forcing a different use is right now power we don't have, but moving that direction. I mean, Pittsburgh's ordinance is the right to sustainable energy, and then defining what sustainable energy actually means. So it's a way to set that bar for the community. Yeah, that's a good question.
Thank you.
Yep.
Hello, Mr. Linzey.
Hello.
Hi. So what I'm going to say, I feel like is a little controversial. So before I even say it, I want to say
like we haven't been talking controversial.
Oh, I know, exactly. But I just want to say that I love this school, and I really thank you for coming here and speaking to us, because it's really, I'm sure, opened a lot of eyes and a lot of minds. And I thoroughly consider you, and around here, this is a great compliment, a very enlightened being.
Thank you.
So, my question regards a rumor. All right, it's a little more than a rumor because I'm pretty sure it's true. But our meditation program that a lot of meditators come here to do is called the Invincible America Meditation Program. And it's been losing funding, a lot of funding. As a matter of fact, it was going to end as of last year. However, a certain financier who has a lot of stock in fracking came to the school, who is also a meditator, and said, hey, I'll give you some money. You can keep some people on and meditate. I just want your opinion. What is more important? letting this stockholder fund our meditation program, or maybe trying to have this stockholder fund our new Bill of Rights?
Security. I don't know enough about the situation to say, but the fact is there are a lot of conflicts that occur in those areas, you know, and that's a decision for this community to make, I think, about whether it's acceptable or not. And on some college campuses, you have a semblance of democracy emerging from student bodies who are now forcing certain decisions to be made by them rather than by the trustees or by the governing board. So that's probably just as controversial as what you raised, but it's really a local decision to be made. I mean, I don't really have an opinion one way or the other. Yeah.
Excellent.
Yeah.
I appreciate it.
Yeah. So we have 5 minutes, I think, maybe a couple minutes. So we'll take 2 more.
Just a quick question. In regards to low-cost green transportation and bicycles in particular, how do you see current laws improving or degrading for bicyclists?
Well, there's a lot being done on the cutting edge of bike lanes and making cities more bike friendly. I think Spokane, Washington is in some ways leading the way in putting in stuff that's supportive of that. There's also bike programs where you can pick up bikes now. Maybe you guys are doing that, I don't know.
Specifically bicycle tickets.
Say again?
Bicycle tickets.
Oh, tickets. What do you mean by tickets?
Like, say, having your motor vehicle license suspended for getting a bicycle ticket.
Oh, wow. That seems kind of crazy to me, but I'm guessing there's a specific story here.
Yes, but my second question is, how much disobedience do you recommend for young people like myself?
What kind
How
of...
much disobedience in regards to these environmental activism such do you recommend for young people like myself?
Lots.
Okay, thank you.
Hi, Thomas. My question is, when you've helped communities that have been trying to keep, say, factory farms or out of their communities, and these ordinances are passed, and I'm wondering, you know, if there is a CAFO that's wanting to come in, do they actually listen to the ordinance? Have you ever had the experience of someone saying, well, this is not law that's been passed by the state legislature or what have you, and I'm going to build it anyway? And then what do you do to address that if they do that?
Excellent question. Most of 160 ordinances, only 3 have been challenged substantively. And so the corporate boys usually steer clear of them because they know that we're trying to catch them in a fight of sorts, that they don't necessarily want to fight because there's 8,000 other places they can go to do what they need to do. And so eventually they'll come back around and challenge X, Y, and Z. But we do have one case right now in Grafton, New Hampshire, where the town hall, because they have town meeting government, passed an ordinance that bans corporations from engaging in unsustainable energy production within the town of Grafton. And the reason to go after that particular issue was the wind turbine issue. They have a proposed development for 65 wind turbines on one of their ridges. So you see the pictures of it. There's clearing the pads across the ridges and then 65 new turbines going in. You can understand why they're upset. The wind company is not paying attention to the ordinance. And so we're talking about enforcement. It's happened in a couple other places where our lawyers will come in and actually enforce the law against them. We don't like to do it because we like to draw the fight the other way. It's cheaper and easier to actually do it that way, but we will enforce, and we stand behind the ordinances to enforce them.
But then how can you, I guess the question is, how do you actually enforce it when it's an ordinance that's locally, but it's not, like the state level can come in and say, well, you know.
It's the same issue you have with them suing. Because if they sue you preemptively, they're arguing the same thing. And the concept here is that the ordinances are really just excuses to begin envisioning a new system that people want and then driving it upwards. That's all they are. And they're everything, and in some ways they're nothing. The fact is they're a new blueprint. But the existing structure of law does not recognize them.
Right.
And so you're going to have judges strike down stuff. And then again, you're going to have judges do funny things. Like in Western Pennsylvania 6 months ago, a judge in a county where we've worked issued a ruling saying that corporations were not persons for purposes of the Fourth Amendment to the Pennsylvania Constitution. And so she said search and seizure laws don't protect them because they're not persons under the PA Constitution. Never seen a ruling like that. May not see another one for a while. But she issued a 25-page opinion where it read just like our democracy school and actually stripped those rights, refused to recognize them. And so you will get real living, breathing judges at the local level, especially elected ones, who actually see the stuff and see a disconnect and will do the right thing. Doesn't mean the Supreme Court's going to do it. Doesn't mean any other court's going to do it. But at the same time, that's not the purpose of this work. The purpose of this work is not to actually continue to listen to the courts as they interpret existing law that we didn't write. And so it's all about drawing that confrontation, that challenge, doing the best you can in court, whether it's an enforcement action or something coming against the government, and then using that to build the future scaffolding that you need to make the state and federal change done.
Thank you.
Yep.
Thank you. I think you might have answered my question in your last, when you were describing what that judge did as far as stripping.
Did you get a bike ticket too?
Did I get a bike?
Did you get a bike ticket too?
No.
Oh, okay. Right.
I don't even know what you're talking
Now
about.
the other guy's question about bicycling.
I didn't understand a word he said. So, you mentioned that she stripped in that particular area the corporation of their humanhood, their individuality, or being written as a person. And my question was, would it do any good at this time from this level to think in terms, because that's a big issue, think in terms of having our attention on that one thing, to strip the corporations of their personhood, since that was an additional thing at some point into the Constitution. Yeah. It wasn't an original thing of the Constitution, correct?
No, we may have disagreement on that. The Constitution was written in such a way that corporate personhood was inevitable.
Oh.
And so it has deeper roots than that.
Okay.
But if we build the organizing around one issue, as big as it is, then what you come out the other side with is a movement focused on that one issue.
Yes,
that doesn't solve the problem.
Gotcha.
And so it's got to be multifaceted enough to solve the problem.
And to add that into our sustainability constitution, would that be the appropriate direction to go?
Yeah, I think if you guys in Fairfield, and this is all just conjecture because there's no guarantee anything's going to happen in Fairfield, to be honest. But if something does happen and folks here heard enough stuff and want to do something, that a sustainability bill of rights would actually include those provisions.
Okay.
So corporations' rights, corporate rights stuff, preemption stuff, right to local self-government, all that stuff coming in, as well as the issues on sustainability.
And I want to say I was participating in your democracy school and loved it.
Great.
And have read everything you gave me, and I highly recommend that everybody take the next one.
Yeah, thank you. Okay. So John, I think you might be the last one tonight. Sorry.
That lady was the last one.
Okay. I have a drive tonight. That's why I was trying to. I'm sorry.
I wanted to say the same thing. He needs to go to Cedar Rapids tonight yet, and it's past 9:30, and then he travels tomorrow to Colorado. So on behalf of our whole community and our university, we want to thank you for your vision and your energy and your focus, and wish you all the best, and see what we can do to organize around that same vision here in our community.
And as Bob said, I mean, we're all in. We help efforts like in Fairfield that come together. So if something gets put together here, we're there for you as a resource. The issue is not funding for us per se, because we're funded. We have grant writers. We do that kind of work. We'll make do and offer the help that we can where we can. But it's going to take funding to get something off the ground here. I mean, just really stupid expenses like photocopies and meeting space and all that kind of stuff has to be taken care of. So if anybody can reach in their pocket and help out, that's the best guarantee to get something off the ground. It always sounds mundane to ask for money, but that's, small bits of money can go a long way with this particular work, especially when you have us behind you helping you do the legal stuff and everything else for free.
Thank you so much.